A legal blow now in the Armstrong murder. The Madras High Court has quashed the preventive detention of 17 accused under the Goondas Act. The court pointed to glaring lapses in due process, wondering how the Chennai Police Commissioner could have possibly scrutinized over 14,000 pages of documents in just one day. Before passing detention orders, the bench, comprising Justices M. S. Ramesh and B. Lakshmi Narayanan, held that this made it clear the detaining authorities had not applied their mind, a key legal requirement under preventive detention law. The court observed that preventive detention is not meant to punish but to prevent future offences, adding that a careless or mechanical approach renders the entire purpose meaningless. Addressing concerns from the state, the bench also clarified that quashing a preventive detention order, however, does not impact bail decisions in the criminal case. It urged bail courts to treat both processes as legally distinct. Now, the case once again throws light on the misuse of preventive detention law and raises questions over procedural integrity in high-profile criminal cases. Let me now go across to a legal mind to understand what this is. Satish Kumar, advocate, Madras High Court, has joined us. Thank you very much, Satish, yet again for joining us on the South Indian. You know, just explain it. Now, you and I were discussing the Armstrong case yesterday about the delays which have happened, about how, you know, even the identification parade has not happened. You and I know about the Armstrong case where 2 or 3 people, Saravanan, for instance, they were shot dead in an encounter. I mean, it looks like a right royal mess. But this preventive detention, and the curious thing about reading 14,000 pages overnight, like you said yesterday, Satish, that anything is possible. Just explain this for the viewers.
But still, I stand by my statement, what I said yesterday. Because if the police wants to wrap the case at the earliest they can do, in case they want to extend, they can do it. In this case, especially, I think the order has been given only against the Goondas Act. Of course, because the materials produced by the evidences produced by the prosecution side has not been proved or has been done in a proper way. That is the reason observed by the Honorable High Court is quite really, you know, the hands of the High Court have been made like that because due to the lack of approach by the prosecution authorities. Whether it has been done deliberately or they are unable to do it because that question is still raises our eyebrow. It is unanswerable so far. Whether the police is going in favor of the so-called people who got arrested under the Goondas Act. Now, the court says that what the court observed is to some extent is right. A person who is not an offender and accused cannot be detained unnecessarily in the prison for no mistake of his part. So that is, of course, the law is very clear. But in this case, and when we were discussing yesterday, they in the Armstrong case they said we all seen the media reports. They have not conducted the identification parade by saying the media reports, and even the CCTV footages have not been produced. So if the CCTV footage had been produced, then naturally the person who were all now detained would have been caught under the Goondas Act itself. And it is highly surprising how the police has taken this case so lightly, but it is such a sensitive case in Tamil Nadu that a state political leader of a national party was murdered brutally in the daylight, and the police is in a careless manner they are handling this case. In case they are the true offenders who have been released, now the probability of some more offense is open. In case, presuming on the other side, in case they have been detained wrongly, that itself is also wrong on part of the police.
All right.
Now you have left the actual offenders.